do you have health insurance? And it says yes. And then it says, are you currently enrolled in medical assistance program? And it says yes. It doesn't give any specifics as to the carrier or the insurance company, but the suggestion here is to pay this, and yet, according to our guidelines here, that I'm glad we got them, but according to this here, we shouldn't be paying this. Maybe Mr. Keenan's got a better answer.
Senator Anderson, Representative.
I guess my question for this would be, is the amount that we're paying what the individual had to pay themselves, like their deductible? We're not, like, if insurance covered, I don't know, 10, 20, 50,000, whatever that number is, we wouldn't pay that. But my understanding of that is that if the individual paid their bill, their portion, which is whatever the number was again, then we could pay them back for the amount that they paid out of pocket, if my understanding is correct.
Mr.
But
Keenan.
our rules don't say that.
Senator Anderson, I, having over a decade on the health committees, I'm aware that a lot of the plans, the first X number of dollars are out of pocket, or there's, even for a visit, you pay a certain fee. So maybe staff could tell us, Mr. Keenley.
Mr. Chair, Senator Anderson, so the rates that these are paid out to the providers are the medical assistance rates. So they are sort of the equivalent of that. I think as far as claims for injuries outside of the the statutory claims that come to us, I'm not sure that the rules were written to cover this particular statutory provision versus somebody who is sort of coming from with a claim outside of the Department of Corrections. I'd have to look at the rules more closely. I know that again, in the past, what has been billed, the Department of Corrections has only paid the portion at which they have been charged for these things. So, again, they would have a better idea of what was or was not covered by insurance. And there may be somebody here that can talk through that, how the billing for these works, for incarcerated individuals who are currently incarcerated. The Department of Corrections is paying for all of those medical expenses. So, in this circumstance, again, there may be somebody that can give more detail on that, but I do know that these are the reimbursement rates that they are charged here are the medical assistance rates, which again could be corresponding to, as Representative Frederick said, the amounts that need to be paid under those. And I'm not sure about the finer details of that.
Can you clarify if my understanding is the process requires some sort of a documentation submitted with the claim. Is that the standard procedure?
Yes, Mr. Chair, there are again, we have the billing records here from Centricare for these health insurance claims forms. Again, the technical on medical billing is not a specialty of mine. So, parsing through what these insurance claims forms mean, again, if there's detail that we can get on that, we can certainly ask for that detail.
Any Senator Carlson, sorry.
So somehow there's a different thing.
Senator Anderson, did that
Well, I'm
answer?
just going by the rules. But I guess never mind.
I understand, Senator Anderson. One of the things that this committee does is, for some of the claims, we are the last avenue. And we have to use our best judgment and provide justice and fairness. Any further questions or motions? Representative Frederick.
I would just move that we pay the amounts as indicated by staff. The $151.78 for Mr. Horseman and $698. Can we do this as one motion? Yeah. $698.08 for Mr. Ron.
Senator Anderson. In SOP for the committee, we have frequently bundled like ones, unless you prefer a different activity on one of the two. So Senator Anderson. Well, what I'm hearing is that there's a request to divide the motion made by Representative Frederick. And so we can divide that motion into two separate motions. And the first one would be to approve the Horseman for 151.78. All in favor, say aye. All opposed, nay. That passes. And the second half of the motion would be Ron for 698.08. All in favor, say aye. Opposed? It passes. Thank you.
From the department, right? Oh, I'm not finding it. There a reason why that's done. That. Oh. Wow.
Why?
Mr. Chair and Senator Carlson, traditionally that number has been the sort of the placeholder in the skeleton for the claims bill as it has been introduced. With that number, that can obviously be amended by the subcommittee. But that number has gotten rolled into one number for purposes of, it's just because it's a reimbursement to the Department of Corrections and not to individual claimants. That number has gotten rolled together and been part of the initial bill as it's been introduced.
Senator Anderson.
Thank you, Mr. Chair. Again, I've written down here, I just put taxes ? About this money that goes back to the claimants. Are they now, is this taxable income to them?
Mr. Chair and Senator Anderson, no, in this case, they wouldn't be, because this is basically the reimbursement for the medical expenses. So how that works. It is tied into, insurance type treatment of those. So, for what was reimbursed, it was basically a payment by the Department of Corrections to them. And so for these claims, we are just reimbursing the Department of Corrections. So this amount of money, the amount of money in this part of the appropriation is just going to the Department of Corrections to pay for the pieces that they were paid for on the other side. And because these are the way that the medical expenses are set up on this, it's no different than, again, the care that an incarcerated person gets in the Department of Corrections. Like, those costs aren't taxable to them, the services that they're provided, and because of their their status, similar set of rules apply in these types of cases.
Mr.
Senator
Chair,
Anderson.
Mr. Keenly, so these claimants are still incarcerated, is that correct?
Mr. Chair, Senator Anderson, these ones are the ones that come through this avenue are not. They are still within the Department of Corrections umbrella, but they are not incarcerated. They're out on work release or sentence to service, those
Okay.
type of programs. They are in the community, but still under the jurisdiction of the Department of Corrections.
So, Mr. Chair,
Mr.
Mr. Keenly,
Senator.
if they were still in prison or jail and things like that, would that money go to a bank account that they would get instead of a check that would be, or how does that work as far as money that comes from the state to them?
Mr. Keenly.
Mr. Chair, Senator Anderson, for medical expenses, those are just covered directly by the Department of Corrections. And so there's never a transfer of
Oh.
funds because they would just go to the Department of Corrections
On their
position,
behalf.
or, if they needed to go outside of the department, to the emergency room, the Department of Corrections just pays those bills directly instead of again, in this case, because they're not within a Department of Corrections facility, they're going to a private medical provider and then being billed and then being reimbursed, and then we're reimbursing the Department of Corrections.
Thank you.
Thank you. And to the people watching, this committee meets, well, the last time we met was April of last year. So once a year, it's a bicameral. And so there tends to be a little bit more refreshing on the specifics because we do operate slightly different than the average committee. So the next item on the agenda is the Department of Corrections injury claims. The first injury claim is the Booth claim. Mr. Keenly.
Thank you, Mr. Chair. Claimant Booth asked for compensation for an injury to his left finger that occurred while he was performing assigned duties. The distal bone of claimant's left middle finger was fractured when it was crushed between two grates. Medical records show claimant wore at least 2 different splints over a month after the incident. There was progressive healing of the fracture and no medical evidence of a permanent partial disability. Hearing and denial is recommended.
Questions from members? Senator Anderson.
Thank you, Mr. Chair. So is the denial from the Department of Corrections or is it from Mr. Keenly?
Mr. Chair and Senator Anderson, that's both the recommendation of the department and my recommendation based on the standard by which the subcommittee has worked on injury claims has been using the workers' compensation scheduling, and for those the subcommittee awards partial permanent disability based on injuries. And so, if you cut yourself, if you break a bone, but you heal up completely, again, the Department of Corrections is paying for all of those medical expenses, which in workers' comp, the employer would be paying for those. But there's no ongoing permanent injury in this case. Someone just broke their finger and it healed. And so both the recommendation of the department and my recommendation is to deny this claim.
So, Mr. Chair,
Senator Anderson, I think Mr. Leonard or Mr. Booth is available on Zoom, and we can get his testimony and then we can take further discourse.
Yes. Hi, how you guys doing today?
Thank you. Please state your name for the record.
My name is Leonard Deontay Booth.
And begin your testimony.
So the DLC is claiming that I didn't sustain a permanent injury, but that's absolutely not true because my background, I worked in assembly, and now I had to go get a forklift driver's license, and I'm doing forklift now because if I stand there and do assembly for too long, I get aches and pains in my finger. I went back to the doctor, which I was rewarded a medical marijuana card. That's where they wanted to start at for my treatment for chronic pain. So the DLC is saying that I did not sustain a permanent injury, but the injury is still going on because I can't really, if I sit there for 8 hours a day and work with my finger is aching the next day. So, so that's a little misleading. That's the only reason why I wanted to log into the Zoom here, and so we could all have a clear understanding. And I can provide the paperwork from my doctors saying that I'm still doing ongoing care for my finger. It was not posted throughout the DOC that they had a hook in the when I worked in the kitchen, they have a hook in the office that the security officers is supposed to get, but they didn't get it. They don't have no signs up letting us know that they instructed me. I was learning to do it with my hands. I smashed my finger and broke my finger in prison, and they should be held accountable for it because I'm still having chronic pain. I can't do my type of work that I love to do. I'm not a forklift driver. I do assembly work, and it's been really hard for me to find a job down here in Rochester because of that. Because I know that I can't sit there and do 8 hours a day with using my fingers or using my hands. No, I can't do that anymore. So that's all I have to say. That's what I wanted to log on to let you guys know today.
Well, thank you. Was there testimony from Mr. Herbert or Mr. Keenly?
Mr. Chair, I was just going to say, if there's additional information that can be submitted to the subcommittee that shows, what I have to work on is what is here in the record. And so if there are other things to be added to the record, that can certainly change the recommendation. So, if one option that the subcommittee has is to lay this over for additional information to be submitted to the subcommittee, and I can look at those medical records and do follow up on that if there is additional information that was not submitted with the original claim.
Any member questions or motions? Senator Anderson.
Mr. Chair, I'm looking through the language that was written here about, and it looks like the last time he had been seen by a doctor was in May of 23. And I'm just wondering if he's seen a doctor recently in the past 4 or 5, 6 months.
Thank you. Mr. Booth, when was your most recent medical appointment for this in relation to this?
I was just back to the DOC and I just had a physical. The lady gave me a physical and she was in there asking me how my finger was doing and I was letting her know. And I just was violated and went back to the DOC for 90 days. So, and I had to have a physical with the doctor there. And I was letting her know that my finger still wasn't, it'd be aching if I use it a lot. And basically that was it. They don't give you much care in there. I mean, and if you keep going down there, you're going to get charged. So, and I was only there for a short time, but I have a doctor on the streets who I work with, not the DOC doctors. I have my own doctors who I work with. And yes, I can provide the information if y'all need it.
Thank you, Mr. Booth. So yes, if you could provide the doctor that you're seeing outside the DOT, that information. It doesn't sound as if that is in our information that we're making.
I didn't even know, honestly, I didn't even know that this meeting, the lady was looking for me. This meeting came to me short notice. I couldn't even get my stuff together because the lady got in contact with my parole officer. I didn't even know that this hearing was coming up. She got in contact with my parole officer, sent him an email. My parole officer come Friday to my house and tell me that I got a hearing today, which is Monday. And I'm like, nobody gave me a notice on when this hearing was. I have stuff that I need to get together. You know what I'm saying? And this just came as a short notice with me. I didn't know that the meeting was going to be today because I would have provided you guys with the additional information that I needed. It was just so short notice.
Mr. Booth, we understand that situation and we don't have a difficulty with you providing additional information and us looking at it at our next meeting, if that's something that you would prefer, or if there's a motion by any of the members of the committee. Senator Westland.
Thank you, Chair. I make a motion to hold this claim over.
Further discussion? Seeing none, all in favor say aye. Opposed, nay. It passes. Okay, the next item is an injury claim with Mr. Wilson and Mr. Keenly.
Thank you, Mr. Chair. Claimant Wilson asked for compensation for an injury occurring while performing assigned duties. Claimant was cleaning a pulper in the facility kitchen when he cut his finger. Claimant was referred to health services where the cut was cleaned and bandaged. At a follow-up appointment 3 days later, claimant's finger was not bleeding and showed no sign of infection. Claimant was able to flex and extend his finger. No further follow-up is noted in the medical records. There's insufficient evidence that claimant has a permanent injury. Hearing and denial are recommended.
Members, any discussion or motion? Representative Frederick.
I'd move to deny the claim.
Thank you. Any further discussion? Seeing none, all in favor say aye.
Aye.
Opposed, nay. It passes. Next item is the claim, is the Jackson claim, Mr. Keenly.
Thank you, Mr. Chair. Claimant Jackson asked for compensation for a head injury. Claimant states that he was performing assigned duties at the time, making him eligible for compensation under Minnesota statute section 3.739. There's no mention in the 7 pages of incident reports that claimant was performing assigned duties at the time. Additionally, claimant's work assignment at the time of the incident did not have duties in the area where he was injured. There's insufficient evidence that claimant was performing assigned duties at the time of the claimed injury. Hearing and denial are recommended. And members, just to give you again more background on the statutory section that I mentioned there, 3.739, that authorizes payment for injuries that occur when a person is doing work for the facility. So work in the facility kitchen, this isn't if you get injured in a facility, it's if you get injured in a facility while you are working for the facility or doing something in a capacity, which is why we then use the workers' compensation system, because it is basically a workers' compensation type claim. But those incarcerated persons are not eligible for workers' compensation.
Members, any discussion? Senator Anderson.
Thank you, Mr. Chair. I think in somewhere I just seen here that Mr. Jackson was going to testify or maybe he was going to testify. It shows here in it says to hear if dear Durante Jackson will be testifying or not. He won't be? Oh, okay. Mr. Chair, I move that the claim is denied.
Thank you. Is there any discussion for members? Seeing none, all in favor say aye. Opposed, nay. It passes. The next injury claim is the Lynch claim. Mr. Keenly.
Thank you, Mr. Chair. Claimant Lynch asks for compensation for permanent damage to his left hand. Claimant was performing assigned duties when his wrist was slit by a metal strap on the wood bundle he was carrying. Claimant had a 7 centimeter laceration across his wrist. Claimant also had previously sustained substantial damage to that hand from an earlier unrelated accident. Claimant had sensory loss, including new symptoms consistent with the additional hand trauma that he sustained, including carpal tunnel-like symptoms and newly diagnosed ulnar neuropathy. Claimant had surgery to remedy these symptoms while incarcerated. Medical records show that claimant's sensory loss improved after surgery, but some sensory loss was still present. It is unclear from the medical documentation whether claimant attained maximum medical improvement. This was before he was released. Claimant is currently not incarcerated. If rated from the current documentation without deducting the pre-existing impairment, claimant would have a partial permanent disability of 18.625% of the whole body, resulting in a partial permanent disability payment of $17,600.63. Medical records from before the work accident suggest some level of sensory loss to claimant's hand, but not as significant as claimant experienced after the work accident and potentially after surgery. The medical records suggest a pre-existing permanent median nerve deficit, assigning a sensory loss of moderate to the fingers or parts thereof fed by the median nerve, that's the thumb, index finger, middle, and radial side of the ring finger, results in a reduced partial permanent disability of 6.875%, equaling a $6,531.25 payment. Hearing and payment are recommended. Alternatively, the subcommittee could require retesting to determine whether the prior testing was consistent with maximum medical improvement.
Is Mr. Lynch on Zoom?
I'm sorry.
Please state your name and begin your testimony.
Yes, my name is Victor Lynch. And do I start my testimony?
Certainly, go ahead.
Okay. The injury that I've sustained that happened prior to this was 20 years ago, for one. And for two, I have very limited use of my left hand. I can't make a fist. I can't write on my left hand. I can't hold silverware. And this is what I have to go through the rest of my life. Now, then it also said that they didn't do that. The physical therapy was not offered at Fairbolt. Anybody can check it. They said 15 minutes every 3 months. This is something that has to be physical therapy 3-4 times a week. They laughed at me and said, not in this facility. You'll have to wait till you get out to resume physical therapy. Well, then now everybody's saying that they're not paying for nothing or this, that, and the other. And I've suffered enough with the injuries that are going on with my hand. And now that I have to live with this the rest of my life, I just cannot afford to go pay for physical therapy out of my pocket because, they said that they offered it in Fairbolt 15 minutes every 3 months. Why? I don't even think I had nothing but 3 months left at this time. So the physical therapy people said, well, just wait until you get out so they can do it appropriate, do it right. Because 15 minutes every 3 months is not going to make a difference when it comes to trying to get at least half usage back on my head to at least be able to hold on to something, go up a ladder if I have to, anything like that. So that's my testimony.
Thank you. Is there anyone from the department wishing to testify?
Are you asking me?
No,
I'm sorry.
I was checking to see if there was anybody in the room that,
Oh,
and there is. Please state your name and your affiliation and begin your testimony.
Good morning. My name is Alex Herbert, legal analyst with the Department of Corrections. Was there a specific? Good morning. My name is Alex Herbert, legal analyst with the Minnesota Department of Corrections. Was there a specific question pending or?
I wanted to give an opportunity to the department if there is clarification on the physical therapy aspect or any aspect on this claim.
Without looking at the database of the medical records, I couldn't speak to the physical therapy that would have been recommended or whether those occurred. It's something we could definitely look into our records for. But based on the available internal records that were referencing Mr. Lynch's pre-existing injury and the extent of that, but without test results kind of giving us a baseline of what the degree of that injury was prior to his in-custody injury, we were not comfortable recommending payment at this time. So we'd respectfully stand by the recommendation in our letter to the subcommittee, which would be denial of the claim.
Thank you. And, any clarification on Mr. Keenly?
Mr. Chair, as far as the documents that are again available are the documents that are available, and an ongoing need for what the ongoing need for physical therapy is certainly something that is within the jurisdiction of the subcommittee to consider. There, because of the timing between when the surgery happened and when Mr. Lynch was released from incarceration, the medical records in that time period are relatively thin. Even given that, again, that there is certainly, based on that, in my review of those, I came up with the recommendation because there certainly is a substantial, there's evidence in the medical records of a larger function loss after he sustained the second injury than he had before, after he sustained his first injury. Because there are not great medical records from before the first injury, specifically setting a baseline, there is a little bit of guesswork. I've attempted to do the best that I can with the record in front of me in making recommendations on what sort of a reasonable baseline is for the prior injuries. But if there are ongoing medical costs, that is something that, again, the subcommittee has certainly within its jurisdiction to pay those. I don't have any medical records, both either in the Department of Corrections records from before his release or afterwards, stating the type of physical therapy that would be recommended and what that physical therapy would be for. There was nothing in the medical records. The way that I rated the injury was based on sensory, because there was no evidence of functional loss, but there was evidence of sensory loss. If there is also functional loss, that's not reflected here in any of the medical records that, for the 2 years of injury between the 2 years of time between when he sustained the injury and when he was released. So based on the fact that there was little to no, actually, I cannot come up with any evidence from my memory of the records of any functional loss. Everything was mostly sensory loss, and physical therapy is not going to change a sensory loss. The sensory loss portion of this. Again, there were functional, I guess I should say, I did not see any there was nothing in the medical records that suggested a different functional loss after his second injury than after his first injury. There is records of functional loss because of his first injury. Those things didn't change, or there's nothing in the medical records that suggests that those things changed. And I don't have any evidence to baseline, to see a baseline change from his previous function loss to his current function loss. There certainly is that on the sensory side. And again, that's what is rated here and recommended for payment here.
I can't pick up a pencil.
Members? Senator Carlson.
No, sorry, Mr. Chair, the determination is 18% disability at $17,600, but then the next paragraph talks about less permanent disability of 6.875% equaling $6,531. Is that what you're saying is your recommendation now? And is there a difference in opinion between that recommendation and the agency recommendation to deny the entire claim?
Mr. Keenly.
Mr. Chair and Senator Carlson, yes, there's a difference between my recommendation and the department's recommendation. The department's recommendation is because of the prior injury to deny the full claim. Based on my review of the medical records, I think there is function loss there. The 18.625% for the $17,000 is the whole loss of sensory, his entire sensory loss. When you're doing a workers' compensation determination, you figure out what the full loss of function is and then assign that to a prior injury and a current injury. And so the entire function loss is the $17,000. Subtracting off the previous injury gets down to the $6,500 for what the additional sensory loss based on the second injury is.
And Mr. Chair,
Ms. Senator Carlson,
was the timing of the first injury?
Mr. Chair, Senator Carlson, I believe it was in the early 2000s. 2005.
2003, I think it was.
Senator Carlson,
I moved we paid $6,531. Reduced amount.
any discussion with members? That does follow past practices of prorating if there was an existence of a previous injury. All in favor, say aye.
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 Opposed, nay. It passes. Okay, the next item on the agenda is Department of Corrections property claims. We'll first take a look at the claims that have been recommended for hearing by the council and then ask for any other claims that members would like to be heard. Ms. Sandy will summarize claim number on the first agenda item. Mr. Baker.
Good morning, committee. I'm Maureen Sandy, co-counsel for the subcommittee. As chair said, we'll start with the first claim recommended for a hearing. Claimant Robert Baker files a property claim of $117.46 for missing headphones, a watch, plastic containers, washcloths, a brush, project box, sweatshirt, hobbycraft beads, 2 pairs of Reebok shoes, and an ankle brace. Claimant was transferred to the restrictive housing unit on 3 separate occasions where the Department of Corrections staff packed and inventoried claimant's property. So on the first pack-up, which was May 24th, 2024, staff confiscated claimant's grays, which is clothing, containers, and lids. The property report shows that staff packed all of claimant's tracked property, and the May 25th signed disposition record states that staff returned his containers and his lids. Claimant retrieved his property on May 29th and filed kites, only reporting that his bowls and project box were missing. Staff responded that all of his property were either packed or listed for disposition. Claimant filed a claim on June 14th for his container, his project box, ankle brace, brush, and watch, but these items are not tracked and they are not noted as missing, and the containers were already returned to him. Moving to the second pack-up on July 20th, 2024, the property report from that pack-up indicates staff packed all of claimant's tracked property, and the July 21st disposition record shows that staff confiscated claimant's sweatshirts, sweatpants, long johns, and containers. The record indicates that staff returned those items on July 23rd. Claimant filed a kite on that same date, stating he was missing his headphones, watch, and washcloths, but only the headphones in that list is tracked. Staff responded that his headphones were marked as present. Moving to the third and final pack-up from that period, on July 31st, the property report shows that staff packed up all of claimant's tracked property and filed a disposition record dated on July 31st, indicating they confiscated 2 pairs of Reebok shoes, 1 sweatshirt, and beads. The disposition record from that pack-up and the property report contain notations from staff. The staff returned all of claimant's confiscated items and also note that claimant's headphones were missing. None of the disposition records show that staff confiscated his washcloths, the brush, project box, ankle brace, or watch. Per DOC policy, these are canteen items, and canteen items are not tracked because they're easily traded, they're easily shared. So they are not tracked in that way. As such, there's insufficient evidence that staff is responsible for these missing items, and council recommends denial of those items in the claim. According to the record, as the department offered claimant $39.56 for his missing headphones, and claimant had refused that offer. As the record reflects that the department took responsibility for missing the headphones, council recommends hearing the property claim and offering the claimant the $39.56 as compensation for those headphones.
Thank you. Members, any questions? Any motions? Senator Anderson.
Thank you, Mr. Chair. I'm just curious as to, the department's offering $39, excuse me, and 56 cents for headphones. And yet we're making an offer, or the suggestion is, to pay the claimant for the $117.46. What's I'm kind of confused as to the difference between the two, as to why one is 117 and one's $39. I just,
If you look on the spreadsheet, the claimant requested amount is the 117.46.
correct.
The determination was the actual value was the lower one that was just stated. Oftentimes there's a discrepancy between what is claimed and what is determined to be the value. And we decide what seems to be the fair route. Ms. Sandy.
Thank you, Chair. And I believe the 117.46 is the claimant's request. He's including the headphones, a watch, the plastic containers, the washcloths, a brush project box. So more things than just the headphones. Because the department doesn't track those separate items, it's hard to know whether it was shared. There's no evidence that staff was responsible for the loss of those items. But because the department took responsibility and noted that they did misplace the headphones, the recommendations is to reoffer that same amount that the headphones were worth. And I believe, according to the department, that was $39.56.
Thank you. Any further discussion? Representative Frederick.
Mr. Chair, I'd move to approve the claim for up to $39.56.
Discussion on the motion. Seeing none, all in favor say aye.
Aye.
Opposed, nay. And it passes. The next one is Haverston, number 17 on the list. Ms. Sandy.
Thank you, Chair. The second claim recommended for hearing is the claim by Dean Hooverstein. Claimant Dean Hooverstein files a property claim of $800 for missing Nike shoes, hobbycraft beads, headphones, and books. On September 5th, 2023, claimant was transferred to the restrictive housing unit, and Department of Corrections staff packed up and inventoried claimant's property. The property report shows staff packed claimant's Nike shoes and noted that his headphones did not bear his identification number. The property report shows claimant had property in excess of his 2-bin limit, and the excess property was placed on a disposition record. The disposition record dated September 27th, 2023, gave claimant 30 days to choose to either dispose of or ship out his excess property. On September 27th, 2023, claimant retrieved his property and signed his property report without noting any of these items as missing. Claimant's claim form indicates he first reported his Nike shoes as missing on October 5th, 2023, which is later than the 24-hour requirement for reporting missing property. According to the department, staff provided claimant with a new set of headphones with proper identification. In a kite dated October 9th, 2023, claimant asked staff to ship out his beadwork that was on his disposition record. According to the record, staff misplaced the beadwork and provided claimant with replacement beads. Regarding the rest of the excess property, which included claimant's books, claimant failed to respond within 30 days regarding the disposition of those items. So per DOC policy, staff disposed of the property on October 27th, 2023. There's insufficient evidence that staff is responsible for claimant's Nike shoes, headphones, and books. Council recommends denying the property claim for those items. There is sufficient evidence that staff is responsible for claimant's lost beadwork. Council recommends hearing on the property claim for the beadwork, but makes no recommendation on the payment of the amount for that.
Thank you. Members? I guess I would have one question of, has there been any payments granted in the past for beadwork? I know that's a very broad, general, and variable. Mr. Keenly.
Thank you, Mr. Chair. The subcommittee has on a few occasions offered payment, some sort of payment for artwork, beadwork, those kind of things that have been misplaced, destroyed, not sent out when they were supposed to be. A lot of these times it is the claimant's view of the value of their artwork and the view of the more objective view of the value of the artwork are sometimes in conflict. But there certainly have been instances per rules, there's a maximum $100 value for these types of things. I know that there have been, again, in the past, there have been instances of somebody doing artwork for their niece that was supposed to be sent out and then got lost in the shipment out. There have been other incidents like that where the subcommittee has authorized, I would say, typically those payments have trended in depending on what the size and scale is, anywhere from $20 to $50 for those types of losses over the course of what my knowledge of the property claims of the last 8 years or so.
Thank you. Senator Anderson, you had a comment or a question?
Mr. Chair, I was just going to ask the DOC if they've had, I see they're wanting to deny this, but the fact is that it's already been mentioned that there was evidence that the DOC or staff people misplaced the beadwork that the claimant claims he's entitled to as far as being replaced. I just wanted some comment from the DOC if they have any on this, why, if there was an actual misplaced on this, and yet why would they deny that?
Please state your name and association and give us some clarity.
Mr. Chair, my name is Morgan Queen. I am the Legal Affairs Coordinator at the Department of Corrections. Regarding the beadwork, first of all, and I think Miss Sandy mentioned this, it is a hobby craft item, and so we do not track those, and we typically say that they're not compensable. Here, staff did make note that the beadwork was misplaced, and so in the record, it appears as though we offered him beadwork that we had in stock to replace what was misplaced. The claimant was okay and accepted that at the time, and then later filed the claim for the missing beadwork, although we replaced the beads. And I thought one other note, I'm not sure if it's the case here, but for DOC policy, any completed hobby craft items, so should this have been a completed beadwork project, it is something that he would not be allowed to keep. He would have to send out, and we would not reimburse for that.
Senator Anderson.
Mr.
did
Chair,
that
I didn't
provide
see
clarity?
that in the writings that they offered to. Did they, is there some place where I missed that verbiage? That the DOC offered to replace that? Or, and he refused, they refused to take it? Is that true?
Ms. Sandy?
The record shows DOC did offer replacement. There's also in the claimant saying that there were tribal beads, and so not knowing what value the replacement beads were, the fact that it was a completed project, not just beads replaced. I think there's some value in the fact that we have compensated artwork, completed projects. There is in the DOC policy, it does state about projects being sent out, but then there's an assigned max value for supplies of $100. Again, that's just talking about supplies. It's not talking about the actual completed work, what the value that could be attributed to that. So I think that's within the committee's jurisdiction to determine.
Thank you.
Senator Anderson. It's nice that we've got the corrections person to give us some clarity and some additional, but it comes down to us to determine what we think is fair and just on this. Senator Westland.
Thank you, Mr. Chair. It does say in the report provided by the DLC that's consistent with the testimony that states, unfortunately, the beadwork had been misplaced, but the property department had beads in stock that Mr. Hoverston accepted in exchange. He's claiming $600 for his beadwork, and I guess I would be inclined at this point probably to agree with the denial of the claim.
Thank you, Senator. That sounded as if the intent for a motion. Does anyone want to?
I can make
Senator
that.
Westland.
Thank you, Mr. Chair. I'll make that motion.
The motion would be to agree to deny the claim. Further discussion? Seeing none, all in favor say aye. Opposed, nay. It passes. The next would be claim 21 on our list. Coney. Ms. Sandy.
Thank you, Chair. The third claim on the list is the claim by Derek Coheney. Claimant Derek Coheney files a property claim of $60 for a beard trimmer. On August 29th, 2023, claimant's beard trimmer was confiscated by the Department of Corrections staff as contraband because it appeared to be altered. Staff reported the confiscation in an incident report and recorded the item in claimant's property disposition record. Per DOC policy, claimant would have 30 days to appeal the confiscation before staff would dispose of the beard trimmer. Claimant utilized the department's internal appeals process and filed several kites regarding the confiscated beard trimmer. The kites dated August 29th, September 12th, and September 27th contained staff determinations that the beard trimmer was altered and did not belong to claimant. In the record, claimant pointed to an earlier confiscation in the same year where the beard trimmer in a kite dated May 24th, 2023, staff stated the beard trimmer was not altered and belonged to claimant. On October 18th, 2023, staff ultimately disposed of the beard trimmer per the 30-day policy. Claimant filed grievances on several forms and letters dated on October 5th, 2023, November 22nd, 2023, December 7th, 2023, and finally with the Ombuds of Corrections on March 26, 2024. On April 5th, 2024, the investigator for the ombuds denied the claimant's appeal. The investigator commented that they were unable to verify the status of the beard trimmer because staff had already disposed of it, but held that staff actions were not unreasonable and were according to policy. As the record shows, multiple staff agreed that claimant's beard was altered, confiscated, and disposed of per DOC policy. There's insufficient evidence that staff action is responsible for claimant's property. There is, however, a question on how the department's 30-day policy aligns with the ombuds appeals process. As such, council recommends a hearing on the appeals process, but makes no recommendation on the property claim and payment.
Thank you. Any questions or motions? Senator Anderson.
Well, just that was, Ms. Sandy just read that there is a question of how the department's 30-day disposition policy aligns with the ombuds appeals process. I guess that's a question I would have with the DOC.
And it looks as if we will receive that clarification. Again, state your name and affiliation and begin your testimony.
Mr. Chair, Senator Anderson, Morgan Queen again with the Department of Corrections and Legal Affairs Coordinator. I had sent clarification about this in an email. Our offender property policy governs the disposition process and the appeal process. The receipt of the completed property disposition record by the incarcerated person starts the clock for the 30-day holding period and the appeal process. And so the incarcerated person may appeal removal of their property, as we see that Mr. Cohen did here, to the property supervisor within 10 working days. After getting a decision from them, then they've got 10 days to appeal to the division head as well. Per our policy, this is an internal appeal process in which the division head's decision is final. Because the Office of the Ombuds for Corrections is separate and independent from the DOC, filing a complaint with them is not part of the DOC's internal appeals process.
Thank you. Is there further clarification, Senator Anderson?
Well, Mr. Chair, I'm trying to read the DOC's explanation as to why they got rid of the beard trimmer and the process for Mr. Coheney. It's almost like it's because of the alteration of the beard trimmer, supposedly, that they got rid of it, but really he's claiming that the beard trimmer was not. Anyway, it's confusing to me as to what's being said and what's being portrayed here. So I'm suggesting that we should pay the claim, but that's my thoughts.
Representative Frederick.
Thank you, Mr. Chair. I think the thing that stands out to me the most is that he pointed to the kite from on May 24th, and reading that they were taken away from him where they were claimed to be altered then, but he got them back because they weren't altered. And so knowing that there was that happened once in the past, it makes me question why they were taken again. So I think I would agree with Senator Anderson that we would pay something.
To the testifier, did you have any feedback on that?
Mr. Chair, I would just note a 3-month time difference there on the initial review of that beard trimmer. It is possible that it was altered after that. And I will just reiterate that multiple staff did review the beard trimmer with their own eyes and noted that the name was sanded down and his name added. which per our policy, it would be contraband.
Representative Frederick.
Thank you, Mr. Chair. And I guess my question to the testifier too then would be that if we have a precedent though, where it's being taken away because it's quote altered, but then given back to him because someone at some high different level said it's not altered, you can have it back. How are we supposed to trust then that the next time that it was taken away, that time it was altered? Because I agree with you that that 3 months time frame, yes, things could happen. Yes, it could be altered in that time frame. That's real. But since we already have a precedent in this case with this individual that the trimmer was taken away, claiming that it was altered when it later was said it was not, how then are we supposed to trust that this time that it actually was altered in some way?
Mr. Chair, Representative Frederick, I would just note that we trust and as we investigate these things, that staff are following policy, and that's one of the things that the facility claims coordinator and us at central office claims look at. And I would just say that a different result, different times that something may have been confiscated would be attributed to the IP's right to appeal. And I can't speak much to the first instance, but the appeal would have gone to the same people, and we trust and look for staff that followed policy on the appeal.
Representative Frederick.
Mr. Chair, do we know what an approximate cost of a razor would be that we're looking for here? How much does he ask for? $60? Then I would move for approval of the motion for $60.
Okay, so any other discussion before we vote on the motion? Seeing none, all in favor, say aye.
Aye.
It passes. The next item is 33 on the list, Mr. Suggs. Sandy.
Thank you, Chair. The fourth claim recommended for hearing is the claim by Deshaun Suggs. Claimant files a property claim of $123.82 for missing shoes and clothing. On October 18th, 2023, claimant was transferred to the restrictive housing unit. Department of Corrections staff packed up claimant's property and took an inventory of the property present and missing. Claimant's property report from that pack-up notes that staff packed a white pair of Nikes and a black pair of Nikes. The comments in the property report state that claimant's property were all accounted for. Claimant retrieved his property on November 17th, 2023, and was informed by staff that some of his personal clothing was transferred to a different facility that would house claimant's brother, who at the same time was transitioning through the restrictive housing unit. Staff had offered claimant $45.41 for claimant's missing clothing, and claimant refused the payment, stating that he also wanted payment for those missing shoes. Claimant filed a claim on November 21st, 2023 for his Nike shoes, white Nike shoes, and personal clothing. The record indicates that claimant was not wearing his white Nikes when he was transferred to the restrictive housing unit and that staff had packed it. The record shows that claimant signed the property report without noting any property was missing. Therefore, there's insufficient evidence that staff action or negligence is responsible for his Nike shoes. Council recommends hearing the claim and re-offering claimant $45 for his personal clothing that they acknowledged they packed away, and denying the claimant's claim for his shoes.
Thank you. Members? I mean, it looks as if the difference between what was offered and what was asked for is a little over $75. representative for the,
Mr. Chair, are you advocating that the committee approve the full amount that's requested, the $123, or?
I was just, pointing out the delta, between, the offer and that amount.
Then, Mr. Chair, I guess I'll just start for the conversation. I'll make a motion for the approval of the $45.41. And if anybody has feelings otherwise, we can certainly talk about it.
Further discussion? Seeing none, all in favor of the $45.40 amount, say aye.
Aye.
Opposed, nay. And it passes. If there are any other property claims that council has not recommended for hearing that members would like to bring up, this would be the appropriate time. Senator Anderson.
Mr. Chair, do we have to, it says here it's being held over. Do we have to make a motion to that effect that it's going to be held over or just?
Uh, Senator Anderson, the past precedence has been making a motion for the remaining claims to take the advised determination from staff. And if they're advising to hold over, that would be taking their advice on that. If they're advising to deny, would be taking that. If their advice was to approve, would be taking that. So one single motion could encompass by taking the recommendation of staff on the remaining items for the property claims.
Mr. Chair, I move to deny all the other property claims except for the one property claim for Mr. Deshaun Thomas to be held over.
Thank you, Senator Anderson. Further discussion? Seeing none, all in favor signify by saying aye.
Aye.
Opposed, nay. And it passes. If there's no further business before the subcommittee, we are now adjourned.